and Tom for his speech, and call Richard back to the floor to deliver the negative team's reply speech.
Mr. Speaker, both sides in this debate thought that it was a travesty when big businesses could avoid tax law and avoid paying their bills. But what we thought was that the tax office was not the best institution to change laws retrospectively, and that when you implemented this policy, you would get worse tax reform and less tax reform, and that was something we didn't stand for on the negative. I've got two issues in reply. Firstly, should the tax office be able to change these laws retrospectively? And secondly, how do we get tax reform best? So to the first issue. And what we got at first was no clear conception of what they thought tax loopholes were or how they operated. So what we told you was that tax loopholes and caveats came about as a result of necessarily long tax codes, which were large documents. It was really hard to interpret what was a loophole and what was the intention of Parliament. What we thought was that a lot of people under their model could be innocently caught up when trying to do the right thing with their taxes, despite their objection that that's not what the debate was about. But what about those dodgy people that were just trying to avoid their taxes? I told you that this increased those people's incentives to offshore their businesses. At second, the response was, these businesses do offshore anyway, and that's like good enough. But what we thought was that when you increased, that they increased those incentives, and they also increased the disincentives for good businesses to disclose financial reports at AGMs like above the bare minimum of the law. At third, they seem to be saying that what they were actually just doing was changing the presumption of guilt and would bring people before the court. If that was the case, we didn't understand what was the point of the debate, because what they got was no difference. They weren't actually retrospectively declaring things illegal. They were just pulling people before a court where their lawyers could battle it out in front of that court and prove that what they had done was a loophole or a caveat and get away with not paying that tax in the first place. We were happy to change tax laws to get people to pay more tax, but we did not think that should be retrospectively. We gave you a whole heap of analysis on why that retrospective lawmaking was bad, because that's what the debate was about. We told you that people had a right to be free from arbitrary fiat of the law. Laura even told you about how the tax office had incentives to create more forms of evasion so it could be seen to be doing its job correctly. We said it made it hard for people to engage in business freely, and people would be much more secretive in their business dealings. We thought they were all huge harms. What to the second issue? How do we get tax reform best? Because we agreed on our side of the house that it was bad when businesses avoided tax laws, because the old tax codes increased evasion and increased the ability for there to be loopholes and caveats. So we thought that when you reform that, you're going to get a more cohesive tax law that would be better. What we told you though was that Parliament is much less likely to engage in reform under their model. Two reasons. Firstly, in tax reform, there was always a winner and there was always a loser. If Parliament could outsource that job to a bureaucratic tax office, it would be less likely to ever engage in that large-scale reform. Secondly, we said that Parliament was wary of imposing additional costs due to the increased risk that perhaps something would be found to be retrospectively illegal. The response was that Parliaments are making bad laws currently because of lobbying power. We didn't think they changed that lobbying power of those bodies under their case. But secondly, we thought that if they really just wanted more revenue, then we could just reform the tax codes to make these businesses pay that tax. When you got tax reform, you got those fairer laws that they wanted. We also thought that the tax office was not a better institution to engage in this, because their lawyers that they want to talk about aren't actually in the business of retrospectively determining what is legal and illegal. Mr. Speaker, we got better tax law and we got better incentives for reform. We were proud to oppose.
Thank Richard for his reply. I call Asher for the affirmative reply.
really said explicitly, although it seemed to be implicit in the case of pretty clear, what they thought of general anti-avoidance provisions. Because all of their rule of law qualms about the idea of interpreting specific legislation in certain ways after the fact that somebody had filed the tax return is in itself retrospective judgments based on that. This debate was about shifting the actor who makes that decision. Quite simple. Their conception of the rule of law on the side of the House is quite simply absurd. Think about it. If you follow it through to its logical conclusion, it requires that every action of the executive branch of government requires a court to okay it in the first place, right? Rather than having a quasi-judicial executive function, which is then checked by the courts after the fact. We gave you plenty of reasons why we prefer the former to the latter. Let's talk firstly about who we were talking about in this debate. Because at the beginning they tried to spin it as though this was going to fall disproportionately on small businesses. And small businesses and big businesses alike were going to suffer from business uncertainty. They were never able to instrumentalise the harm of business uncertainty. But we also didn't think it existed in this debate, right? If you don't understand the problem in the tax code, it's really quite simple, Mr. Speaker. You call up the IRD and you say, hey guys, here's a possible loophole. What do you think is the proper interpretation of this? Will you consider this to be general avoidance? You do that phone call, you hopefully don't get caught out with that after the fact. Even if you do get caught out, you're going to be able to defend yourself in court, and if you were truly innocent, then you're not going to have to pay your tax bill. No great harm. Let's talk then more generally about whether or not we're going to get more tax over here or more tax over here, because that's what seems to be what this debate is about. So they accepted the idea that it's probably good if everybody pays a fair and accurate amount of tax. They largely accepted our mechanism of what, or gave you no good reason to believe, why the courts were somehow more efficient at assessing these kind of questions than the tax officers. We gave you plenty of reasons for that, right? They mainly attacked general avoidance provisions. What were their three core attacks? Firstly, they said, secrecy is a massive problem. These guys aren't going to be disclosing their reports in their AGMs right now. Well, the problem with that, Mr. Speaker, is people currently want to avoid tax, and if this way of avoiding tax is to just never give the government any of your documents, how is it that we're ever able to get any information out of these corporations in the first place, right? Obviously, we have some mechanisms by which we're able to say, if you don't tell us how much you're earning, don't operate in our country or our jurisdiction, right? It's that simple. As far as the next challenge went, it was that the IRS or the IRD or whoever it is lacks resources to take this kind of judicial review or defend themselves in these judicial review challenges after that. Yes, the IRD lacks resources as compared with multi-billion-dollar corporations. That's what this debate was about, right? It was about advantaging the IRD as against the corporations and adjusting the system so the advantage didn't go against them. Why? Because now the incentive operates on a corporation to only ever go to court if they truly believe that they can convince the court that they weren't avoiding tax, rather than the current incentive, which is to go for court for as long as possible without paying your tax bill to run out that statute of limitations and demand that the state prove that you were avoiding tax. The state doesn't have as much information, they never gave you a good reason to believe why they would. The final attack was this notion of reform, right? And it was very confused as to exactly what they meant about reform and how this mechanism worked. First thing they said was, well, the corporation's incentive is going to be to make the tax law more ambiguous. But in a higher risk situation where you're more likely to be prima facie labelled as an avoider, why would you want more ambiguous tax provisions which make it harder for you to determine whether or not you're an avoider? That makes no sense whatsoever. They also had this conflicting conception of tax codes that one, they were forever uninterpretable and forever complicated, and then on the other hand, their reform movement was somehow going to make crystal clear tax codes. We've operated under the system for hundreds of years, Mr. Speaker. We've been chasing and chasing corporations as they've become ever better at tax avoidance. Our traditional system does not work, and following the same old ways is not going to suddenly pull reform out of the hat like a white rabbit. The tax office can't keep up according to their conception. Well, how on earth can the legislature? If you want to avoid taxes, under our model, you're going to have to defend yourself. We pass.
Thanks very much to Asha and to both of the teams in this debate. While the teams are shaking one another's hands, I just have a couple of announcements for the audience.